issue that we have on the agenda. And this evening, we're dealing with something that's a very difficult conversation to have, especially given that we are in the middle of a global pandemic. We know that people have been economically affected by the pandemic. And so having this conversation becomes quite difficult because it's not an isolated conversation. So much of it really is happening at the backdrop of what is happening, not just in South Africa, but across the world. And we're tackling a landlord's guide to dealing with a non-paying tenant. Unfortunately, one of the things that has been happening, particularly right now, is that tenants, some of them aren't able to pay their rent. Some of them are actually just taking chances. They're probably still fully employed, still getting 100% of their pay, but for some reason are not sticking to the rental agreement and paying their rent in full. We're going to be looking at what a landlord can and cannot do in the event that their tenant stops paying. And I think the important thing isn't just the what you can do, but also what you cannot do. Because I think far too often landlords tend to, unfortunately, do illegal things to get rid of their tenants. So we do say, do not do that. You want to follow, what the law says in terms of dealing with a non-paying tenant as much as possible. And to help us better understand the legal implications, what we can legally do and what we legally absolutely should not be doing when it comes to this matter, I'm joined by Bruno Simao, who's the founding attorney at Bruno Simao Attorneys. Of course, he's no stranger to the Private Property Podcast. We've had him before, and we will certainly be having him back on the show. Good evening, Bruno, and thank you so much for joining us.
Good evening, Zama. It's really, really good to be on. Thank you. Thank you for the invitation.
Thank you so much for honoring that invitation. And of course, to our viewers at home, if you have a particular issue that has to do with the non-paying tenant, then do share your questions and comments with us. Perhaps you've encountered this one before. How did you go about remedying it? Perhaps you're in the middle of that situation right now where you've made, let's say, verbal agreements or even agreements where you've written things down, but they're now not sticking to their end of the bargain. Do let us know, what issue you're facing with your non-paying tenant. So, Bruno, let's start with the dues, right? Because the reality is there are tenants who are either right now not paying, and some, as I was saying earlier, could very well be because of the economic crisis that we're finding ourselves in. And some could just very well be taking chances, because we've seen, I've certainly seen quite a lot of accounts of people who are saying, look, my tenant says, their pay has been affected. I've asked them to provide proof. And when I do that, then they start paying. Or when they send through those bank statements, their salary hasn't been affected. So what is the first thing a landlord should do in the event where it's now the first, let's say second or third, that rental amount has not come in? What's the first thing that as landlords we should be doing?
Sure. So, look, I think it's very important to distinguish because there's going to be some elements that are going to be impacted pre-COVID and post-COVID, and they're going to be slightly different one to the other. But the one thing that has always stayed consistent is try and move as quickly as you can insofar as the enforcement of your rights are concerned. So second day of the month, assuming that rental's payable on the first day, send out that letter of demand, right? It doesn't have to be seen necessarily as aggressive. It is part of the process in order to start basically the clock ticking down. You need a certain amount of days before you can even consider canceling. So by the second, instead of potentially wasting time trying to make phone calls, next thing you know, it's the 7th, the 9th, the 12th, the 15th, and no letters have been sent out. Do that on day one. And sometimes you'll find maybe 50% of the cases, you'll get a payment. And I would say that if you look at the dues, and the first thing that a person would have to do is just get that letter of demand off as soon as possible. Just for the benefit of your viewers, so there is also a level of understanding on what I mean by a letter of demand. And this is a very big warning that people need to look out for. A lot of lease agreements, especially if not drafted properly, sometimes make reference to a 7-day notice period.
Yeah.
Right? Please, guys, be very, very careful. In South Africa, we have the Consumer Protection Act. Now, 7 days is a great period for most contracts to remedy a breach. But if the Consumer Protection Act applies to your contract, 7 days is not enough. You need 20 business days. So that's also another reason why I say send the letter out on day one after the breach. Because if you think, oh, but it's 7 days, it's 1 week, it's not too bad. It's not. It's 20 business days, which is tantamount to 1 month. So... and where does the CPA apply? most residential leases because a landlord that leases a property out to a consumer or a person for the purposes of getting income in is effectively running it as a business. It doesn't have to be his primary business, but it is still a business. So most residential leases fall under the CPA. So guys, be careful. That's 30 days. Send out that notice immediately.
And I was actually going to ask you which ones fall under CPA, because I can already imagine, landlords thinking, wait, is mine applicable? Is mine not applicable? So then we find it's the second, because let's say on the first, even as a landlord, your debit orders are going off, you didn't really, check, but it's now the second, you're on your banking app, you realize actually, the tenant hasn't paid any rent, and you send out that letter of demand. And I'm asking this question for the DIY landlords. So the landlords that probably have perhaps one, property, rental property, perhaps two, and they're doing it themselves as opposed to working by an agency. What does that letter of demand say? Like, what is in that letter of demand? Because I can imagine if you're running your own portfolio for the first time and you just thought, look, I'm buying this, I'm going to have a tenant. You probably don't even A, know what a letter of demand is, B, what effectively goes into a letter of demand.
Cool. No, perfect. That's actually a very good question. So letter of demand need not be complicated, but it does kind of need to be precise on what it's addressing. So the whole point of making a demand is to, so basically if a person doesn't pay his rent, if he falls into arrears, he's in breach of the agreement. So we then look at the actual contract itself, and we have to read through the clauses that deal with breach and what they say. So very often they will deal, for example, with how notice is supposed to be given. So very old school contracts used to still require notice by way of a registered post, which now shouldn't be the case. I mean, if your contract still says that, guys, you need to change your contract because no one uses registered post anymore. It's simply, we cannot trust it. It's a nice way to prove that something's been delivered, but we just never know whether it's ever been delivered and whether people even collect registered post anymore. So things like emails are a lot more common. Hell, even faxes is something that we don't use anymore. So you'll find
nobody uses a fax, Bruno. Absolutely
no, exactly.
No, I feel like millennials don't even know how fax machine work. So we do not speak of faxes at all.
No, absolutely. So the only thing left is really emails that we tend to use, or hand delivery. There's nothing wrong with that. But the contract will guide you on what needs to be done. So that's the first port of call, is there, you do need to look at the wording of the contract. And then, of course, you need to look at the legislation. And both of these need to be read together. And to a certain degree, if the contract conflicts with the legislation, you have to give precedence to the legislation. So, for example, you'll find a letter of demand says, if a person falls into breach and fails to remedy that breach, say within 7 days of receiving notice by email, you as a landlord are entitled to cancel. Now you look at that and you go, great. Now what does the legislation say? So is there anything stopping me sending it via email? No. Okay, great. So I can send it via email. Oh, but it says 7 days. Bruno said that there's a 20-day requirement. Okay, wait, that's wrong. Let me make it 20 business days and not 7 days. Okay, fantastic. It speaks about breach. What does that mean? Well, what has he done wrong? And what are you demanding he rectify? Because both the Consumer Protection Act and most lease agreements say you need to ask him to rectify his breach. So you do have to be precise, because you need to tell him what he did wrong. It cannot be so ambiguous that the tenant doesn't actually know what he did. And it might sound funny to landlords, because some landlords are like, come on, if he doesn't pay rent, I mean, seriously, he knows what he did wrong. But you have to look at it objectively. There's certain circumstances where you could be demanding, for example, maybe there was an escalation and no one spoke about the escalation, and you send a demand and you're not precise enough. Or, the person played loud music and you're not being precise as to what actually happened and what you feel he's in breach with. So be precise on what he did wrong, be precise on the number of days he has to rectify it, and obviously deliver it properly so that it's in compliance with the contract. And ultimately, you follow those three principles, you should be good with a letter of demand.
And one of the things that you've highlighted, Bruno, that I've sometimes seen landlords do particularly with their lease agreements, and especially DIY landlords that either buy a lease agreement or perhaps download one online and then want to add their own clauses, is more often than not, it actually doesn't stand the test of a valid contract, because they are putting in clauses that, quite frankly, are not legal, and they think that just by virtue of putting it in there and a tenant agreeing to it suddenly means, well, you've agreed to this, therefore I can hold you up to it. But I think the very important things for landlords to understand, that you cannot put an illegal clause in a contract and think that it's going to be valid. So that's why it's so important to make sure that your lease agreements, especially as you start even getting more and more, tenants on, that you have really thorough lease agreements. You're able to work with, attorneys. It's not that expensive to just get a very standard lease agreement from an attorney, and they'll essentially make sure that it's up to the latest legislation. All the clauses are, the way they're supposed to be. And you're able to actually ask them, am I able to add this kind of clause? They say there's a particular thing that you want mentioned. Perhaps there's things about, and I mean, we see this one, which is fairly normal. You don't want any drilling on your wall. So if you want to put something like that around, no drilling, if somebody does that, then they'll be liable for it. That's perfectly fine and normal. So you're able to have that conversation with them. And it's so important that you do that, because you will think, look, I'll just DIY it. I won't pay that. Let's say it's 850 to consult with an attorney and for them to draft one for you, because you want to, save those rands and cents, only to realize that you've essentially entered into a contract that is not valid with your tenant. And once you start a dispute with them, then that starts coming up, which ends up costing you quite a lot of money, down the line. So just be sure that when you want to save on those rands and cents, you're saving at the right places, as opposed to kind of cutting corners and doing it yourself. We always talk about the importance of, having a power team, but also working with a team of professionals. And an attorney is somebody who needs to be part of your team. And that's one thing that you cannot escape when you're in property. Whether you are going to be buying, you're selling, you're renting, you certainly need a legal eye to be going through a lot of those contracts for you. So make sure that you invest in that and build a relationship with the firm that you want to be working with. Talk payment structure and those kinds of things, because it's so crucial to have the right legal team. I think legal issues can be so sticky that you definitely don't want to find yourself on the wrong side of a contract. So Bruno, we've now gotten that letter of demand out, and let's say our tenant, doesn't respond. What is then the next step? I mean, they're living there, because oftentimes the unfortunate thing is I've seen landlords who will, sometimes perhaps let it slide those first week, perhaps that second week, they'll send emails, they'll send WhatsApps, try to call, perhaps the tenant doesn't respond at all. Then they start resorting to wanting to change the locks or changing the door, taking down the door. I mean, I've heard all kinds of horror stories around what landlords have done trying to remedy their tenant not paying rent on time. So once the letter of demand is out, then what would be the next sort of possible step that we ought to be taking?
So at this juncture, the next immediate thing that needs to be done is the cancellation letter. Quite simply put, you've given the person notice, you've given them a period of time to comply, they failed to comply. So you do need to cancel the lease agreement. Why this is important is proceeding with an eviction, for example, cannot be done unless the person on the property is unlawful. And for the person to be unlawful, there can't be a lease agreement in place, which is why the cancellation is so important. That's not a difficult process. So if you ask me again about the DIY landlord, it's literally a letter saying, I sent you that letter. You haven't responded. You failed to remedy your breach. I hereby give you notice of cancellation effective immediately. Something along those lines will do the trick, and at least then you can get the ball rolling. So that's fairly simplistic. It's the steps after that start becoming a lot more strategic.
And we're going to go through some of those steps. I want to take a quick break, Bruno, and we're also going to be taking questions and comments from our viewers at home. I've already seen some questions coming through on YouTube as well as on our Facebook. If you are a landlord, perhaps you're a DIY landlord, you're handling your property portfolio by yourself, what kind of challenges have you faced with non-paying tenants? How have you gone about to remedy that? Perhaps it's something that you're struggling with, especially right now. And I also actually want to hear from the tenants. If you are finding yourself in a very difficult, financial situation right now, have you tried to have a conversation with your landlord? Because perhaps one of the big things, and you certainly would have picked this up even in previous episodes, is we always say try to be proactive as much as possible. Don't sit down and not communicate with your landlord, because they're not going to know that you're now in a financially difficult position. And I think especially right now at this stage of the lockdown, I mean, we've been through so much that in many ways sort of normal life has resumed, whereas during the stages of the hard lockdown, we were having the conversation, constantly monitoring. Now people are almost assuming we're back at work. Some people are going into the office. So perhaps your landlord may not be as proactive in initiating that conversation. So as a tenant, are you doing that in the event where you're seeing that work has cut your pay, perhaps 60%, you're only receiving 60% of your pay, and that rent is going to be affected? How are you having that conversation with your landlord to try and see either you can, get out of your current lease to move into a cheaper place, or making some kind of arrangement with your landlord? We're going to go for a quick break, and when we come back, we'll be taking your questions and comments with Bruno. We'll be back just after this. Welcome back to episode 140 of the Private Property Podcast. I'm your host, Zama. We're kickstarting this week's Private Property Podcast by looking at a fairly difficult conversation, especially given the difficult economic climate that we find ourselves in. We're looking at a landlord's guide to dealing with non-paying tenant. We want to better understand what we can and cannot do legally, or rather what we can and should not be doing, especially as landlords. Sometimes landlords do take chances, which I know we absolutely should not be taking. So we want to better understand what kinds of steps should we be taking in the event where we are dealing with a non-paying tenant. We are, of course, taking your questions and comments at home, whether you're watching us across our social media platforms, YouTube, Facebook, Instagram, or Twitter. We certainly are taking your questions. I want to go to this question that's coming through from our YouTube page, and this one is coming through, Bruno, from Colin Collins, who asks, so the first, actually want to look at the first bit, because we asked him to just clarify what he meant. So he says, hi, Private Property, what can I do with agents that does not pay on time? And when we asked him to just sort of rectify or to better update us in terms of what he means, he basically says the agency or the company that I'm working with does not pay in my rental income as promised at the end of the month. How can I deal with the matter?
So I suppose we need a bit more information to be able to properly answer this. So first, we need to determine whether it's the agent's fault or the tenant's fault. Because I'm assuming now he's a landlord and he's mandated an agent to lease the property and he's not getting the money from the agent. So the question is the tenant paying the agent and the agent is just dragging his feet with releasing the payment to the landlord, or is the agent just simply not receiving payments from the tenant? And because in those instances, the landlord needs to know what his expectation is and where the fault lies. If it's the agent that's dragging their feet, you've got recourse against the agent. You need to find out what's happening with that money. That's even grounds to terminate the mandate. So you can go forward immediately, ask them for a copy of the portion of the account that deals with the monies that's received on your file, because they're supposed to hold it in trust on your behalf. And it's a criminal offense to not disclose that to you and to do anything with the money but pay it to the person to which it belongs. If that's the case, you've got recourse against the estate agent. If the tenant's not paying, maybe there's just some level of miscommunication where the agent hasn't properly explained that there's nothing that he can do. It's incumbent on the landlord to take the necessary steps. More often than not, the estate agents would actually provide the service by approaching an attorney and kind of connecting the attorney with the landlord. I don't know anything about this agent, so maybe this agent isn't as clear or open or transparent, but that's what the agent should be doing. And if he's not doing it, it's up to the landlord to do it, and to make sure that he collects the rent, does the necessary evictions and the like.
I actually just want you to look at the first scenario where the agency is getting the money on time from the tenant, but they're simply not paying it essentially on time to the landlord. And you're saying that they're able to essentially, there's recourse. What kind of recourse is there? So where should the agent, let's say they have that conversation with the agent to say, why isn't money being paid on time? They're able to establish that the tenant is in fact paying the rental on time. Where is the landlord going to report this? What are the, almost quick steps for them to be able to deal with this? Because I can already imagine, I mean, my quick thinking with this one, and I'm putting my landlord hat on, is terminating the service. Let's say you're 6 months into the lease agreement. You would have already paid them their commission, right? So you would have already paid that 1 month's rental to them. So it's actually not to the landlord's benefit to want to terminate it 6 months in, because you'd essentially then lose out on that 1 month's rental that you'd have to give back to the tenant. And probably you don't want to have to manage the tenant yourself. Are you now going to give this money to somebody else? So you're just potentially going to lose money. So where's the best place that the landlord should be going in order to report the particular agent?
Look, it's a difficult question because, and I think even the way that the question's put, like, we know, unfortunately, that the Estate Agency Affairs Board has been, with all due respect, they've been slacking as of late. So ideally, that is the place to go, because that is the one place that kind of deals with the entire situation, because it will deal with misconduct. The connected insurance, Fidelity Fund insurance, would actually deal with any claims of theft, for example, where the money goes missing. So, between me and you, or like legally speaking, that is the place that you'd want to go in order to be able to enforce your claim. Unfortunately, we have seen some delays. So I've had a couple of success stories last year where there wasn't an issue, where the EAB proceeded against the agent, and eventually the agent paid out of fear of being reprimanded by them. But it might take a bit of time. So it's not necessarily the fastest solution. But the one thing we need to remember is there's a difference between, and I tell all my clients this, because this is where you can save a lot of money. There's a difference between practical enforcement and legal enforcement. So legal enforcement is when I tell you, what's a word? So for an eviction, for example, you ask me, but what is the cost? How long is it going to take? What do I need to do? I can answer these questions and I can give you really good scenarios and really bad scenarios, because you're asking me for two extents, best case and worst case. So what should we do? Well, you need to do it, and this is what happens if you do it. It's either here or it could be here. But the reality, for example, when it comes to evictions, is we can get it sorted out here. Sometimes we can get it sorted out by the mere service of a summons and an application for eviction. So the horror stories about 6 months down the line and this is still happening, that's literally sometimes 5 to 10% of the cases. And sometimes you can actually get it sorted out. So it's the same with this. You send a letter threatening the agent that your intention is to report them. And I'm not saying use that as a gimmick. Yes, you're going to report them. But I can promise you right now, any agent that's worth his salt and actually has a reputation to worry about is going to jump up very quickly and try and get that thing resolved before this hits the EAB. So that's just something to remember. Another option, for example, is you can still approach the courts. But again, With approaching the courts comes cost. So a lot of my clients go, listen, why now I want to pay an attorney to go collect rent that's there. I'd rather terminate the mandate, make sure that money doesn't get paid to the estate agent anymore, even cut my losses if necessary, and make sure moving forward I'm covered. So sometimes going to court isn't worth it. So again, it really depends on the person. Sometimes issue the summons if you have to, because it does render a result. It does cause there to be a reaction. Complain to the Estate Agency Affairs Board, even if they take their time, but just make sure going forward, you don't keep making the same mistake. So if there's a problem now, sort it out now, make sure that you terminate the mandate properly and move forward with the tenant so that money doesn't go to that estate agent anymore. So that's more a mitigate your damages type of scenario before you start dealing with the issue at hand, which is going after the arrears.
We've got a question here on Facebook coming from Usmangaliso Sahaka. I love this question. They ask, as a tenant, if I happen to have made a prepaid rent for almost the whole year of 2020, while some tenants are receiving discount rate payment and payment holidays due to the COVID-19 crisis, am I eligible to claim also a future discount or rent payment or payment holiday? This is for the same rental property.
Sure. Look, unfortunately, payment holidays were all discretionary. There's nothing in any contract that required a landlord to give a payment holiday. And I've even seen this being applied across the board, depending on the eligibility of a specific tenant. So some landlords were kind enough to say, it's all right, everyone on my book gets 50% discount. So I've got some owners that have inner city buildings that just went 50% for everyone. And then I had some guys that had to ask the question, say, we cannot afford to give you rental discount. But the reality is, if your salary got cut by 20, I get it. So I'll carry you. Even if it's a deferment where I give you a discount now, you pay me back later, or I give it to you out of the goodness of my heart. But discounts in general were, for the most part, out of the goodness of the landlord's heart. They weren't necessary. I know a lot of landlords have said, no, sorry, that's not part of my business. You pay me later. I'll give you a reduction now in exchange for payment later. So unfortunately, now after the fact, applying for that reduction isn't going to work, because number one, it was almost implied that if you're going to get it, it would have been during that time where everyone was struggling, first of all. And if it's a discount, an outright discount, it was discretionary, which means that you're very unlikely to get a landlord to give it to you. But again, practically ask, maybe go and ask, listen, you know what, I'm really struggling now. I've been a good tenant. Through COVID, you had my cash flow. Please, please, please just help. I want to be able to claim this now. Do you mind? But it's not an entitlement. It's not a right. It's about being human. And I think that also plays a part. If you were a good landlord, for a good tenant for a really long time, and looking at the current market now where people are struggling, people lost their jobs, people might not have the same level of affordability, would you as a landlord not want to keep a good tenant? And I mean, what's he asking for? Maybe 10%, 20%? He was there for you when you needed him. So maybe it's time that you're there for him. It doesn't have to be permanent, 3 months, 2 months, negotiated. So let him ask at least. But yeah, legally, there's no entitlement. It practically, come on, like let's be human as well.
Yeah. And I think I actually like one of the suggestions from Usman, so that in perhaps if not a holiday, then be able to claim sort of a future discount. So you've already paid for 2020. Let's assume you wanted to also stay in the same place for 2021. You've already established that you are paying the rental. You paid the full amount for the year at the beginning of the year. Perhaps you're already now getting into contract negotiations, so to speak, to say next year, I'll also be staying here. I'll also be paying at the beginning of the year for the whole 2021. But let's say this time around, you're able to give me a 10% discount or a 15% discount for the annual payment, because you already know I'm good for it. I've done it. I'll also be doing it next year. So let me get this discount. So I think that's probably a great way to approach it. And I think oftentimes landlords love tenants who are able to pay upfront that kind of money. I know often we get it with even student accommodation, where sometimes the students are being paid for their bursary, where they get the full amount. So I think have that conversation and see where it goes. But as Bruno is saying, there's no legal obligation, certainly on the landlord side, to grant you that. But I think for your own sake and the fact that you're already a paying tenant, you've paid the full amount at the beginning, then make the case for the 2021 period that the rent be discounted. You're still going to be paying the full amount at the beginning of the year. We've got another one here, this one coming in from Claude Wayne, who says, I'm having a problem. My contract finished in February, so it's month to month, and my tenant owes me 40,000. That's 4 months rent. I live in Saudi Arabia. What can I do that is legal to get him out of my property?
Okay, so this comes back to the enforcement provisions that we were chatting about earlier. So after you've done a cancellation and you've tried your best to negotiate, speak to people, try get them to pay, do a bit of soft collection, phone them up, all of that, right? It comes down to the question of what can I actually legally do to get my money or to get the tenant out. I normally advise my clients, first thing you need to remember is keeping the tenant on the property is probably the worst thing for you, because you're going to keep suffering damages. You've tried to negotiate, it's not working, you need to get them out. So before you put money and effort into rental collections, now no one's saying that you can't do it simultaneously, but don't get into a position where you start focusing on collecting the rent and you forget about the eviction. Eviction needs to go out first. Eviction can go out almost immediately after that cancellation is done. You don't need to give more time after the cancellation for a person to move out. So quite literally the next day you can prepare that eviction application, you can get it out, you can get it served on the property. And like I mentioned earlier, right, this isn't a question because a lot of people ask, oh, what's the cost? The costs vary depending on the difficulties. Some evictions can cost 19,000 to finalize. Some are slightly more complicated, might go up to 50,000. But I can promise you this right now. Again, you're asking me, to go to court, get an order, get the sheriff to execute. But 90% of the time, or 80%, let's say 80% just to be conservative, I issue that application out very soon. I don't give the tenant enough time to become complacent. Immediately after the first month, we've tried, no one's answered, and you issue that eviction out, I can promise you half of them will move out. Or sorry, 80% of the time they'll move out.
It never goes all the way where you end up paying that 20,000 or 50,000. Being able to act swiftly early on is going to, more often than not, guarantees that movement is made. And you would have spent substantially less time than had you waited. And I think the big thing for Claudia, when you're out of the country, certainly able to approach, attorneys in South Africa who are able to deal with this, on your behalf, because it's certainly, like we're saying, it's not one of those things where you can go into a property, for example, and change the locks. And even if you're in the country, that's not something that you're supposed to be doing. So in a situation like this, you want to get an attorney on it, because your tenant probably also knows that my landlord is not in the country. There's not much they can do. Right now, it's even COVID, they have travel restrictions. So it probably very easily might also be slightly taking advantage of how you're not close to the property and you're not even in the country. And so, getting the services of an attorney to handle the matter is more likely than not going to also show them that, okay, this person, as much as they're not here, they're mean business and they're quite serious with dealing with this particular matter.
Absolutely.
Bruno, we've got a question here from Carlo Gusen, who asks, are you allowed to ask for top-up deposit at the renewal of a lease?
Yes, you are. There's nothing wrong with that. So remember, at the end of the day, your deposit, it's mostly in the contract, but most of the time your deposits would be equal to a month's rent. So if you're looking at a rental escalation, you're going to be asking for the deposit to be topped up.
10%, yeah.
Yeah. And sometimes, for example, so during COVID, what you found was there were deposit utilization agreements. So to allow for cash flow, some of the tenants allowed for the deposits to be utilized by the landlord. And what the landlord effectively then agreed is, said, great, we'll apply this deposit towards rental payments, but you promise to give me this deposit back. Because remember, it's there for damages. So we'll do this now for cash flow, but I expect you to pay it back. So that's also a level of top up, is basically repaying the deposit if it was utilized for anything out of desperation, firstly, and with escalations, a slight little increase every year.
I am going to ask this question. It's coming from Jackie Haynes on Facebook. It's slightly different from, non-payment of a tenant, but I think it's actually quite an interesting one because they're almost legal matters. I think, if anything, as I was reading it, a part of me was thinking, this is part of what sometimes I know gives us a lot of anxiety when it comes to, for example, your bond agreement with the bank and not reading the 1,000,001 pages that come with it, because it can be quite overwhelming. Jackie asks, my employment contract was terminated due to the lockdown. I last paid my bond in full in March. I did communicate this to the bank. I could only pay 500 Rand of the 3,000 Rand last month on my 18-year-old bond. The bank has a representative calling me from an unattended number to tell me that they will auction my property. What can I do?
Sure. Yeah, look, so it's a very difficult one, and it also depends on the banks. And unfortunately, one of the issues I find with some banks is one department doesn't know what the other department is doing. So I've got a lot of close contacts at the banks, and the way that the people in these departments perceivably deal with some of these issues might not necessarily be what the public sees, but this is almost policy of sorts, or at least the initiative that they're trying to get into. So banks don't want to sell your property on auction, right? It's something that they've been quite open about. Ever since the introduction of Rule 46A of the Uniform Rules of Court, it's become really difficult to sell a property on auction, because now there's multiple things that you need to present to the court. You need to set reserve price. If the reserve price isn't met, you need to go back to court. And, you could be looking at a huge period of time before the property gets sold on auction. So by the time the bank gets to that point, there I'd worry, because the bank has incurred so many costs that the debtor is going to end up paying for it. So what I find is banks are actually willing to enter into arrangements and agreements. So during COVID, I don't know about, I think you said her name was Jackie, but the strangest thing is, well, like everyone was approached by way of SMS saying, listen, we'll give you a certain period of payment holidays. I know that Nedbank automatically asked if you just wanted to extend it for another 3 months. I know that ABSA automatically discounted. Yeah.
So ABSA asked you, so ABSA had the SMS option, and then they asked you after the 3 months if you want to extend it for another 3 months.
Yes.
So they also did that automatic, and I think their process was you're doing a yes or no SMS. There was no need to send any documentation at all.
Exactly. Yeah, exactly. Same with Nedbank. And I know Standard Bank was the one that first came out with that payment holiday, the first to market with it. So it's very strange for me that that wasn't something that she was offered. So that's the first question, is what happened there exactly? Maybe she should approach the bank and just find out, listen, but did you charge me for it? Was it a question of me not replying to an SMS that you sent, so you continue to charge me? Can I get the same benefits as everyone else did? Please help with that. So that already kind of deals with at least till about your August, September, if I'm not mistaken. September was, I know October was when a lot of the places started after the second extension. So that possibly leaves her with a month in arrears. So I'd first look at those 6 months and just figure out what happened with her bank. Now, the second thing that we need to look at is, now she doesn't have a job. And again, it's not, remember, from the bank's perspective, again, they've got no obligation to give any sort of remission or any sort of holiday to a property owner. So we do need to be mindful that they would only be able to do so much before for them it became unprofitable. So she does unfortunately need to look at a situation now. What is her plan moving forward? Because she can approach the bank and come up with a solution. But what solution can she come up with if she doesn't have a job? She can try extend the bond for a period of time, but then she needs to show that she has some form of income in order to do that. So the other option that she has, and most of the banks have this, is a kind of a quick sell or easy sale option, where you say, you know what, if I can't afford to pay the house, I'm going to need to possibly put it up on the market, give a mandate. It also, I know it's a strange thing to say, but it also buys you some time, because the property is going to go to market, and possibly if it doesn't get sold and you find a job, you may be able to go back to the bank and say, look, I can pay you, please cancel the mandate and let's continue with this. And if it hasn't been sold, it's a good idea for both you and the bank. But I think like the realization or reality does need to dawn at some point, where we do need to make a decision on what we're going to do going forward. Otherwise, you run the risk of bank issuing summons, getting judgment against you, that's extra legal costs and a listing against your name. So guys, I'd be very, very careful with that. I would rather cooperate with the bank. Unfortunately, you owe them the money. It's a matter of making a plan on how it's going to get paid back.
Mm-hmm. Well, Bruno, we are going to leave it there this evening. I think when we deal with these matters, there's always so many different kinds of scenarios. And as we were even saying earlier on, sometimes without knowing the full facts of some of the matters, it's quite difficult to, give a very direct response. But I think we've given, viewers at home a nice overview of some of the things that they are, that they can do to remedy non-paying tenants. And I think the very big thing with landlords is don't, change locks. Don't bring people in who are going to scare your tenants. Don't do any of that stuff.
Sorry, if you don't mind me jumping in there quickly, just so everyone realizes, doing that is called an act of spoliation, and the regulations now under alert level 1 criminalize this. So whereas in the past we used to be able to say, people do it, but they can get a court order against you, and people are willing to take chances, please don't do that now. Because now it's actually a criminal offense and it will backfire and you may land up getting arrested for it. So be very careful. Another thing that the regulations also say is you need to try your best to negotiate with the tenant, because you might not get an eviction order unless you do try your best. So in that 20 days notice that you give, try negotiate, try see what the story is. If the tenant's just a little bit short, maybe give some room, because the courts might not want to give you that eviction and might be your best option. So those are just two very important things in the regulations that people should look out for.
Well, Bruno, we're also going to leave it there this evening. Thank you so much for joining us.
Sure, thank you.
And that is Bruno Simao, who is the founding attorney at Bruno Simao Attorneys. We're certainly going to be having him back on. I think one of the big things to understand is understanding the legal, implications of the decisions that we make as landlords, and making sure that we don't make the wrong decisions. Because I think sometimes it's so easy to, think, look, I'm just going to change locks, or I'm going to send people in. I'm going to make their living environment as hostile as possible just to get them to move out. But as Bruno's pointed out, that's something you don't want to do. It can certainly be something that's illegal, essentially, at this moment. So make sure that you do not do that. Well, that's a wrap from me, Zama, here on the Private Property Podcast, and the rest of the team. We're, of course, back on your screen tomorrow evening at 7 p.m. But you can also catch the Farming Podcast, which comes tomorrow at 1 o'clock. Certainly something that you do not want to miss out. Do catch Umbali on the Farming Podcast right here on the Private Property social media platforms. And if you, of course, want to find out a little bit more about farming and various ways that you can get involved in agriculture, that certainly is the podcast for you. Well, until tomorrow evening, that's it from me. And, of course, hoping you're staying home and staying safe.
Besides the beautiful beaches, sunny skies and how central everything is, what I really love about Umhlanga is the people. You can't help but become immersed in the culture, and you'll find people connecting in the most authentic spaces. It's just got this vibe to it. It's hard to think that only a few years ago, these business parks and homes were mostly sugarcane. The rate that this area has been developed at is truly mind-blowing. Especially with the fast pace of life these days, we really pride ourselves in being that bright spot in a person's day. You'll see everything from advocates and CEOs to creatives and students who pop into our spot for that short moment to escape. There's just so much life and energy in this area, and after a hectic week there's nothing better than stopping in at Mount Edgecombe Country Club for a relaxed round of golf. The beauty and serenity that the estate offers really inspires me. There's honestly no place I'd rather live. That's my Umhlanga.